Do you have readiness in the hall?
I do. We're live in the court right now, so I would I just say maybe yes. Good. You weren't saying nothing wrong.
No, but it's what after this.
We're just waiting for the public defender to return.
Okay.
Okay, Mr. Nichol will bring the gentleman that you were meeting with back.
Thank you, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Monique Williams and file number 23-03798 SM, counsel appearance.
Yes, Assistant Public Defender Scott Nichol on behalf of Ms. Williams for arraignment today.
Okay, you're Miss Monique Williams.
Yes, I am.
Okay, Ms. Williams, today's the date set for an arraignment. I do have a misdemeanor complaint here. It alleges that on or about December 26, 2023, at the area of 611 Sadie Court, Apartment 29, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of domestic violence. The allegation is that you did make an assault or assault and battery upon a Ulysses Allen, an individual with whom you had a child in common, or a resident or former resident of your household, and that this is contrary to Michigan Compiled Law 750.812. Restitution may be ordered upon conviction, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with the maximum penalty of 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty?
Yeah.
Okay, you have the right to be represented by counsel. Mr. Nickel from the Office of the Public Defender is present today only for the purpose of your arraignment, but you have the right to have an attorney with you to represent you at each stage of the criminal prosecution. You have the right to be represented by counsel if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. Do you understand that right?
Yes.
Is she requesting the Public Defender's Office to represent her, Mr. Nickel?
She is, Your Honor.
Okay, Ms. Williams, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or you can stand mute. If you stand mute, this matter will proceed all the way through to a trial. You have the right to a jury trial. At the time of trial, you enjoy the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront, cross-examine, or question in court any of the witnesses and your accusers that's called to testify against you at trial. You have the right to call your own witnesses to your trial or present evidence that you believe further defense to the charge being brought against you. Do you have any questions about those rights?
No.
For the purposes of her arraignment, is she pleading not guilty?
Yes, she would enter not guilty plea.
Okay, thank you. Ma'am, are you currently employed?
No.
Is your address the 611 Sadie Court Road address?
Yes.
Is that the address of Mr. Allen?
It is not. He just stays there sometimes with me.
Okay, well, there will be a no contact order in place for the protection of the alleged victim, which means he will not be able, or you will not be able to stay wherever he lives, works, or goes to school. And so he would not be able to come to your house either, because that would place you in violation of that order. Do you understand that?
Yes.
Okay. Are you currently on probation or on parole?
No.
What's your phone number?
517-220-3412.
You're currently scheduled for a pre-trial conference before me, Judge Kristen Simmons. It's going to be Tuesday, February 6, 2024 at 10 o'clock in the morning. Did you get a copy of your notice to appear and the Zoom instructions for my courtroom?
Yes.
You have any questions at this time?
No.
Counsel, you can address bond.
Yes, Your Honor, I did have a chance to speak with Miss Williams this morning. She did not report ever failing to appear for court. She's lived in Lansing her whole life. She has limited prior criminal history, one offense that she reported for which she received and successfully completed a term of HYTA probation. And so based on all of that and the fact that she has an address she can live at separate from the complaining witness in this case, I would request that the court grant her a personal recognizance bond. As far as the no contact orders, the cases the court is likely to enter, I would just note that the parties share children in common. I would request the court consider allowing third-party contact for the exchange of information related to the child, including exchanges for any visitation either party is getting.
Thank you. The bond is set in the amount of $500 personal recognizance. Following conditions apply, ma'am. You need to appear to all of your court dates while you're out on bond. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess alcohol or drugs without a valid prescription. You're not to possess a firearm, ammunition, or any other dangerous weapon while you're out on bond. You're not to have contact directly or indirectly with Ulysses Allen. That includes no third-party contact. If you have issues relative to parenting rights and communication for that purposes, you can deal with that at the family court.
So can I ask a question?
Yes, ma'am.
Does that mean that, like, we wouldn't be able to trade off the child?
No, you're not to be within 1,500 feet of wherever he is.
Yeah, I know that, but I mean, like, me and his mom are really cool, and I wouldn't be able to get my son from her.
Well, yeah, you can have communication with his mom. You just can't
Okay.
send communication to him through his mom.
Okay,
But you can obviously communicate with his mom and anybody else that you want to communicate. You just can't have third-party communication with him, meaning you can't send any messages through anybody else to deliver to him. That's what that means, okay?
okay.
And again, any concerns as it relates to how you parent in that form, that you would need to deal with that at the family court. But I'm not going to get involved with that at this time. Again, you're not to be within 1,500 feet of wherever. Wait, let me see what this order already says. Okay, order, we'll do 2,000 because that's what the order already says. 2,000 feet of wherever the alleged victim, Ulysses Allen, lives, works, or goes to school. Do you have any questions at this time?
No.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, ma'am. Mr. Pfeiffer, which matter are you here for?
I'm here for Hawk, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Trey Hawk, file number 23-03800FY, counsel appearance.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Hawk.
And you're Mr. Trey Hawk?
Yes, Your Honor.
Okay, Mr. Hawk, today's the date set for an arraignment. I have a felony complaint here. The complaint alleges that on or about December 26, 2023 at 202 East Cesar Chavez, apartment 10, that's located in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of assault with intent to do great bodily harm, less than murder, or by strangulation. The allegation is that you did make an assault upon a DeAndre McFadden by strangulation or suffocation, and that this was contrary to Michigan Compiled Law 750.84. That's a felony with the maximum penalty of 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 2 of interfering with an electronic communication. It alleges that you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line, and that this was contrary to Michigan Compiled Law 750.5405A. Count 2 is a felony, maximum penalty 2 years and or $1,000 in fines. There's a count 3 of domestic violence. It alleges that you did make an assault or assault and battery upon a DeAndre McFadden, an individual with whom you had a dating relationship, and that this was contrary to Michigan Compiled Law 750.812. Restitution may be ordered upon conviction, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Count 3 is a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand counts 1 through 3 and the maximum penalty attached to each?
Yes, Your Honor.
You have the right to be represented by counsel. The public defense office is representing you today for the purpose of your arraignment only, but you do have the right to be represented at each court appearance. And you have the right to be represented by counsel if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the public defender's office appoint you at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
Okay. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter will proceed all the way through to your right to trial. You are being charged in count 1 and count 2 with felonies, which means you have the right to have a preliminary examination as to those 2 counts. You have the right to have your preliminary examination within 21 days of today's date being the date that you were arraigned. At the time of the preliminary examination, you have the right to require the prosecutor to put forth sufficient evidence to establish that they have probable cause, that a crime was committed and then probable cause sufficient to charge you with these felonies. Do you understand those rights so far?
Yes, Your Honor.
You have the right to trial and you have the right to a jury trial in this matter. At the time of your jury trial, you have the right to the presumption of innocence. So you're innocent, sir, until proven guilty. You have the right to require the prosecutor to prove your guilt, and they need to do that by proving each element of the charges being brought against you beyond a reasonable doubt at your trial. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront your accuser in court and cross-examine or question any other witnesses that the prosecutor's office calls against you. You have the right to call your own witnesses to trial or present evidence at trial that you believe show a defense to the charge being brought against you. Do you have any questions about those rights?
No, Your Honor.
Is he requesting the public defense counsel to represent him?
He is not, Your Honor. He's informed me he intends to hire private counsel.
Okay, I'll note here that you are declining court-appointed counsel. That's correct, Mr. Hawk?
Yes, Your Honor.
Okay, and for the purposes of his arraignment, will enter a plea of not guilty on your behalf.
Yes, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
Are you employed?
Yes, Your Honor.
Where is that?
Alamo Construction Company, Your Honor.
Your address, the address on Rosemary?
Yes, Your Honor.
Is that the address of McFadden as well?
No, that is my home with my children. I don't live.
I'm sorry?
Nothing, Your Honor. I live with my fiance and kids.
What's your phone number?
517-763-9562.
You're currently scheduled for a probable cause conference before Judge Cynthia Ward. It's gonna be Friday, January 5th, 2024 at 9 o'clock in the morning. That can be held via Zoom or you can appear in person. You have a preliminary examination before Judge Ward, January 12th, 2024 at 8:30 in the morning. That is in person at the court, okay?
Yes, Your Honor.
Okay, Mr. Pfeiffer, were you seeking to address bond?
Yes, Your Honor.
You can do so at this time.
Thank you, Your Honor. This case is a very serious one, which is why my office asked to appear at arraignment today. We are very concerned for the safety of the victim in this matter from the defendant. In this case, he actually stopped the victim from calling police, first by telling him that, well, he's black and I'm white, so the cops aren't going to believe you. And then when he still picked up his phone to call the police, physically removing the phone from his hand to stop him. The victim suffered significant injury in this matter that all indicate strangulation, including marks on the neck, as well as redness in the eyes that happen when there's a block of airflow. Further, he had bite wounds on his back from the defendant. There is a history of domestic violence here that was backed up by the victim's family, who's personally witnessed the defendant attack the victim. Each time the victim has tried to get away from the defendant has followed him, including out of state, all the way down to Tennessee, when he tried to get away last time. As a result of this, Your Honor, the people are very concerned that if there is not a significant bond in this matter, we will have further incidents and that the victim will not be safe from the defendant. The people are asking for $75,000 cash surety, GPS tether, victim notification, and an exclusion zone, as we believe that it is appropriate in this matter. We believe there is a high likelihood of conviction, especially given the fact that the statements the defendant made to police do not match the injuries that the police observed. Thank you.
Thank you. Mr. Nichol.
Yes, Your Honor, I would ask the court to grant Mr. Hawk a personal recognizance bond. By my look at it, he has no prior criminal history. He is presumed innocent of these charges. At this time, I would ask the court to take that reality into consideration. He does not live with the alleged victim of this crime. He has a separate address. If the court wishes to impose conditions beyond that of a no contact order, to allow for additional protection of the community and the safety of the witnesses or alleged victim, the court is free to do that. Further, Mr. Hawk is employed, owns his own business, has stable housing. He's been a resident of the Lansing area since 1998. And, you know, as far as the other allegations that Mr. Pfeiffer is making, at this point, I have nothing to back those up and would suggest it sounds like what we have is potentially hearsay statements from members of the victim family. I would ask that the court grant him a personal recognizance bond. The court can protect the safety of the victim with reasonable bond conditions. The imposition of a $75,000 cash bond would do nothing to potentially hold Mr. Hawk in custody. That would further protect the safety of the victim that can't be accomplished through a no contact order, other reasonable bond conditions. Thank you, Your Honor.
Thank you. Okay, I don't see any prior criminal history on Mr. Hawk's record. I don't see any prior engagement with the criminal justice system. I have here again the allegations of 3 counts, 2 being a felony, the most serious being an allegation of a felonious assault, or I'm sorry, an assault with intent to do great bodily harm less than murder or by strangulation. And I understand the concerns or the statements that was put on the record by you, Mr. Pfeiffer, but I don't have anything that necessarily supports or backs that up. It's not anything that's indicative of this defendant's criminal history. I think that based on what I have before me, that bond could be best served with GPS tether and victim notification. So why would that not be sufficient?
Because, Your Honor, in cases of severe domestic violence, especially with long histories of unreported domestic violence, it frequently happens where the tether then lasts until it's cut. And a cash bond actually provide some lasting consequence for them.
Okay, well, I can recognize that, but just giving the nature of what was shared here as it relates to the defendant being a business owner, clearly he's got a fiance or a girlfriend of some sort, 3 children that he lives with, makes a considerable amount of money. I would hope that he would not want to put his livelihood and their livelihood in further risk by violating the court's bond conditions. He's even willing to hire his own attorney, which shows his investment into defending these allegations. With that being stated, the court is going to grant a personal recognizance bond. Bond will be set in the amount of 10,000 personal recognizance with GPS tether and victim notification. You have the following conditions while you're on bond. You're not to have any contact directly or indirectly with DeAndre McFadden. Do you understand what directly or indirect contact would mean?
Yes, Your Honor.
Okay, so you can't cause anybody to make any communication on your behalf. You can't send any messages that includes conveyances using electronic devices. You can't write any notes, no communication of any kind. You're not to be within 2,000 feet of wherever he is at any time. Do you understand that?
Yes, Your Honor.
You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use or possess alcohol or drugs without a valid prescription. You need to report to pretrial services within 48 hours of your release. You need to appear for all of your court dates. Do you have any questions so far?
Oh, Your Honor.
I know that Mr. Pfeiffer made a statement about a concern about tampering with the GPS, and if something like that were to occur, that's an additional felony charge plus bond violations that I'm sure you don't want to be involved in. Is that correct?
Yes, Your Honor.
Okay, so I don't believe or hope that there will be any issues. And then you'll again appear for all of your future court dates. You did receive your notice to appear and the Zoom instructions for Judge Ward's courtroom.
Yes, Your Honor.
Any additional matters for today's record?
No, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set, Mr. Hawk.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Okay, Mr. Smith.
Good afternoon, Your Honor.
Good afternoon. I don't have that anyone appeared on your 2 o'clock motion to show cause with report to me at Russell. You can have a bench warrant.
We will prepare and submit that, Your Honor, for bond consideration purposes. The balance today, $1,265.75.
Your bond is 10%.
We will prepare and submit. Thank you, Your Honor.
Thank you. You're all set.
Legal services.
Okay, sounds good. Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Bernardo Perez Rosas, file number 23-03799, counsel appearance.
Assistant Public Defender Scott Nichol on behalf of Mr. Perez Rosas for arraignment.
Okay, you're Mr. Perez Rosas?
Yes, ma'am. Junior. Excuse me.
Okay, it's Perez Rosas Jr.
Yes, ma'am.
Okay. Okay, Mr. Bernardo Perez Rosas Jr., I do have a misdemeanor warrant here and complaint. It alleges that on or about December 26, 2023 at 1001 West Kavanaugh Road, apartment 6, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of child abuse 4th degree. The allegation is that you did knowingly or intentionally commit the following act or acts that under the circumstances pose an unreasonable risk of harm or physical injury to a child by committing domestic violence and assault and battery while holding the minor child, and that this is contrary to MCL 750.136B 7 through 8. Restitution may be ordered upon conviction, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Count 1 is a misdemeanor with a maximum penalty of 1 year in jail or probation for up to 5 years. Count 2 is domestic violence, alleging that you did make an assault or assault and battery upon a Kayleen Paddock, an individual with whom you had a child in common, contrary to MCL 750.812. Restitution may be awarded in that count if convicted, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Count 2 is a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. Again, a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's a count 3 of assault or assault and battery alleging that you did make an assault or assault and battery upon the following person, that being a Deborah Paddock, and that this was done contrary to MCL 750.811. Restitution may be ordered in that offense upon conviction, as that offense may have resulted in damage to another individual's property or physical injury or death to another individual. Count 3 is a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand counts 1 through 3 and the maximum penalty attached to each?
Yes, ma'am.
Okay, you have the right to be represented by an attorney. Attorney Nichol is representing you today for the purposes of your arraignment only. You have the right to have an attorney represent you at each stage of the criminal prosecution. You have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney to represent you, you can make a request to have the public defense office appointed at the expense of the public. Do you understand that right?
Yes, ma'am.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute, this matter will proceed to a trial. You have the right to jury trial. You have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at your trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to confront your accusers in court and cross-examine any witnesses called against you. You have the right to call your own witnesses to your trial or present evidence that you believe further defense to the charges being brought against you. You have the right to remain silent at trial and not have silence be used against you. Do you have any questions about those rights?
No, ma'am.
Is he requesting public defense office to represent him?
Yes, Your Honor.
The court will enter a plea of not guilty on your behalf. We're currently scheduled for pretrial conference before me, Judge Kristen Simmons. It's gonna be Tuesday, February 6th, 2024 at 8:30 in the morning. Did you get a
Yes.
copy of your notice to appear in the jury, I'm sorry, in the Zoom instructions for my courtroom?
Yes, I have, ma'am. I got them both right here.
Very good. Are you currently on probation or parole?
No, ma'am.
Are you employed?
Yes, ma'am. I work for DJ Landscape. Excuse me.
Your address, the address on Kavanaugh?
Yes.
Okay, is that also the address of Kayleen Paddock?
Yes, but I'm not staying there. I was just visiting that time.
Okay. Where are you going to be staying?
I'm probably get a hold of my mom or probably stay with my sister. I know my mom stays, so I'm Ferris Apartments on the north side. I'm not sure which apartment though, but I know which building.
What's your phone number?
517-219-3345.
3345?
Yes, ma'am.
You can address bond counsel.
Yes, Your Honor, I did have a chance to speak with Mr. Perez Rosas. I did not report any prior criminal history or any history of failing to appear. He's lived in Lansing his whole life. He is employed. He did inform me he will be able to live with his sister while the case is pending, understanding he won't be able to reside with any of the complaining witnesses in the case. He did not off the top of his head know that address, but I did advise him that he will need to get that address as soon as possible and provide it to the court so the court knows where he can be contacted and located while the case is pending. With all that in consideration, I'd ask the court to release Mr. Perez Rosas on a personal recognizance bond at this time.
Bond will be set in the amount of $500 personal recognizance with GPS tether. You need to provide the court with a valid address as to where you'll be staying within 24 hours of your release. You're not to be
Yes.
you're not to be within 2,000 feet of Kayleen or Deborah Paddock. Do you understand that?
Yes, ma'am.
You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of this court. You're not to possess a firearm or any other dangerous weapon, and you need to report to all of your future court dates. Do you have any questions
Yeah.
about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further for the record, Your Honor. Thank you.
Okay, you're all set. Thank you. This PA 53 says Kathleen Paddock, but I think it should be Caitlin. On the record in the matter of the people of the state of Michigan versus Suzanne Billington, file number is 23-037970M, counsel appearance.
Assistant Public Defender Scott Nickel on behalf of Miss Billington for arraignment today.
Can you step forward, please? Okay, and actually, it says people of the city of Lansing. I think I said state of Michigan. Ms. Billington?
Yes.
I have here a citation. It alleges that on or about December 26, 2023 at 11:02 p.m., in the area upon North Sycamore Street at or near West Ionia Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act of furnishing false information to a police officer, no vehicle involved. That's a misdemeanor, and the maximum penalty is 93 days in jail and or $500 in fines. Do you understand the charge there and the maximum penalty? Can you say that again for me?
Yes.
Okay. You have the right to be represented by an attorney in this matter. Mr. Nichols is representing you today just for your arraignment. You do have the right, though, to have an attorney with you throughout the pendency of this criminal prosecution, and you have the right to have an attorney represent you if you're going to be questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you. Do you understand that?
Yes.
Is she requesting court-appointed counsel?
She is, Your Honor.
Ms. Billington, you have the right to plead guilty. You have the right to plead not guilty, or you can stand mute. If you stand mute, this matter will proceed all the way to a jury trial. You have the right to remain silent. Anything you say and anything that you put in writing can be used against you. You have the right to jury trial, and you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the city attorney's office to prove your guilt at trial by proving each element of the charge of furnishing false information beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You have the right to confront and cross-examine any other witnesses that they call against you. You have the right to call your own witnesses to your trial or present evidence that you believe further defense to the charge of furnishing false information. Do you understand that?
Yes.
For the purposes of her arraignment, the court will enter a plea of not guilty. Are you currently employed?
No.
What's your home address?
125 West Downey, Michigan.
What's your phone number?
I don't have a phone right now.
You're currently scheduled for a pretrial conference before Judge Tony Flores, Tuesday, January 9th, 2024 at 10:30 in the morning. Did you get your notice to appear in the Zoom instructions for Judge Flores's courtroom? Ma'am, did you hear me?
Yes, yes, ma'am.
Did you get your notice to appear in the Zoom instructions for Judge Flores?
Yes.
Okay. Are you currently on probation or on parole?
No.
Bond is set in the amount of 300 personal recognizance. While out on bond, you need to appear to all of your court dates, okay?
Thank you.
I'm not finished. You must also not engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. Do you have any questions?
No.
Any additional matters today, Mr. Nickel?
Nothing further for the record, Your Honor.
You're all set, ma'am.
Thank you.
You're welcome. On the record, in the matters of the people of the city of Lansing versus Wayne Hunt, I have file numbers 15 L2086182 and 15 L2086181. Mr. Hunt, is that correct?
Yes, ma'am.
Okay, I have two failure to pay tickets here. One is an expired plate. And this is an expired plate from 2015. You apparently failed to appear. You did have a show cause on this back in 2018. You were advised that your balance was $222. You indicated to the magistrate that you forgot all about it, that you were working for Causeway Bay, that you would pay $111 by November 16, 2018, and the balance by December 14, 2018. It's now 2023 and you still have a balance of $177. I also have a no proof of insurance, also from 2015. Similar story, October 16, 2018, you were before Magistrate Milmore. You advised that you would pay $123 by November 16, 2018, and the balance by December 14, 2018. Here we are, 2023, balance is $246. How much are you paying today?
I will have it all paid off on Tuesday. That's when I get paid next. All the balance and everything.
We're not open on Tuesday. Okay, we're not open on Tuesday because of the holiday, so you'll pay the balance on both. I'm sorry?
Could Monday be better for you guys?
No, we're
Are you
closed on Monday too. I'm gonna tell you what the next, I'm gonna give you the date in just a moment. You're gonna pay on Wednesday, the 3rd. You're gonna pay 177 on file number ending on 181. You're gonna pay 246 in file number ending 182, so that we can close these files and move on with our lives in 2024, okay?
Yes, ma'am.
You have any questions?
No, ma'am.
That's the only 2 files I have for him, I believe. Okay, then you're all set.
Thank you, ma'am. Have a good day.
Thank you. On the record in the matter of the people of the state of Michigan versus Jose Mandujano, file number 21-02270 FY, council appearance.
Yes, Assistant Public Defender Scott Nickel on behalf of Mr. Mandujano for arraignment today.
Mr. Mandujano, can you hear me?
Yes, Your Honor.
Okay, Mr. Mandujano, I have a felony complaint here.
Yes, Your Honor.
Give me just a moment. The allegations here are that in count 1, you failed to pay child support and that you did not pay support for your child or children in the amount or at the time stated in an order entered by the Ingham County Circuit Court in file number 201500123 DS, and that this was contrary to Michigan Compile Law 750.165. Count 1 is a felony with a maximum penalty of 4 years and or $2,000 in fines. States here that court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest. It also indicates that the outstanding arrearages as of June 28, 2021 is $53,572.30. Do you understand the charge in count 1 and the maximum penalty?
Yes, Your Honor, I understand.
You have the right to be represented by an attorney. You're represented by Mr. Nickel today for the purposes solely of your arraignment. You have the right to be represented by an attorney at each stage of the criminal prosecution, and you have the right to be represented by an attorney if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the public defender's office represent you at the expense of the public. Do you understand that?
Yes, Your Honor.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter will proceed all the way to a jury trial. You have the right in this matter, because this is a felony, to have a preliminary examination. You have the right to have preliminary examination within 21 days of the date of your arraignment, which is today's date, unless that timeline is waived by you or the court finds good cause to go beyond that 21 days. At the time of the preliminary examination, you have the right to require the prosecutor, who is the Office of the Attorney General, to put forth sufficient evidence to establish that they have probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. You have the right to a trial and a right to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element of the charge in count one beyond a reasonable doubt. You have the right to confront in court any witnesses or accusers that is called against you. You have the right to call your own witnesses or present evidence that you believe further defense to the charge being brought against you. You have the right to remain silent at trial and not have silence be used against you. Do you have any questions about any of those rights?
No, Your Honor.
Is he requesting the public defense office to represent him?
He is, Your Honor.
The court will enter a plea of not guilty on your behalf. What's your home address?
My home address is 2160 East Loop, 820, apartment 70, Fort Worth, Texas, 76112.
What's your phone number?
614-980-2050.
Are you currently on probation or on parole?
No, Your Honor.
Are you employed?
Yes, Your Honor, I am.
Where?
Right now I just came to Ohio. Well, I was in Ohio, so I'm working for this guy named Andrew. His company is called Andrew's Painting. And then when I go back home, well, when I'm in Texas, I work for my uncle. His company's called Image Paint.
Counsel, you can address bond.
Yes, Your Honor. I did have a chance to speak with Mr. Mangiano. He did inform me that he resides in Texas, is employed full-time as a painter. He did not report any prior criminal history or history of failing to appear. We would request that the court consider either setting a personal recognizance bond or a low cash surety bond so that Mr. Mangiano can be out of custody and continue to work while this case is pending. Because of the nature of the case, it's important that he continue to work so that he may have an opportunity to clear some of the child support arrearage. Thank you, Your Honor.
Okay, I'm not sure what the age of the case has to do with anything. This is a child support case on a failure to pay child support, with the arrearage just being at the time of 2021 being $53,572.30. We're now going into 2024, so I'm sure that arrearage amount is not up to date. Nonetheless, the defendant will be ordered to pay 25% of that arrearage as a bond in his name only. While out on bond, you're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs without a prescription. and you're not to engage in any assaultive or threatening behavior. Do you have any questions about your bond?
Yes, I was just saying, how much would the bond be, like right now?
Well, right now, the only amount I have is that you owe $53,572.30, but I'm ordering that you pay 25% of the arrearage in your name. So if the arrearage turns out to be more than that, you need to pay 25% of that. So it's gonna require you to do some math, okay?
Yes, Your Honor.
Okay.
So
Do you have
right
any
now,
other
is
questions?
Yes, right now, so is it at $53,000?
As you have $53,000 right now.
Okay, yes, Your Honor.
Again, but that was the amount that was placed on this warrant back in 2021.
Yes.
It's now going into 2024.
Uh,
Okay,
Yes, what do you mean by in my name?
that means that it has to be in your name. You can't have somebody else put their money up or put it in their name. If they're gonna give you the money, that's their business, but it's got to be in your name. That the bond is posted in, okay? You can't have your mother or anybody else post the bond for you. It has to be in the name of Jose Mandujano.
And how would I do that if I'm in custody?
You can make arrangements. You can talk to your attorney about connecting in order to get bond posted, but bond must be posted in your name.
Yes, okay.
Do you have any other questions, sir?
That'd be it.
Okay, any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, Mr. Mandujano.
Okay.
I think that's all I have for arraignments.
Yes, because the only other person I talked to was Mr. Toaz, who seemed to have a bond violation out of 55th, so I didn't expect this court to address him.
Correct, I remanded him to see 55th.
All right, thank you, Your Honor.
Thank you, have a good one.
You too.
Melissa Coleman.
Yes, Your Honor.
Mr. Brownhouse.
Your Honor, we did send in a conditional dismissal on that one. I'm not sure if he was aware that he's still.
I have not seen him, and this matter was scheduled twice on my docket today. There was a morning case with the same defendant, I believe.
Yeah, the cases were consolidated, Your Honor.
Well, they didn't consolidate it on my docket. Nonetheless, Mr. Brownhouse was here earlier today on another matter. He's not here now.
We did submit it by my file, and he emailed a copy to.
Oh, is that, well, I don't know if they. You said you submitted it via my file?
Yeah.
Okay, well, I do have a signed copy here, electronic signatures for both yourself and Mr. Garlandhouse, so we can appear or proceed without him appearing. Okay. This is the matter of Schasberger versus Melissa Ann Coleman in file numbers 23-02760 LTE and 23-03068. Council can have your appearance for the record.
Veronica Pereira on behalf of Ms. Coleman.
Okay, Ms. Coleman, you can hear us, correct?
Correct.
Okay, today was the date that was set in the matter scheduled at 2:30 for a non-payment of rent hearing. There was a matter scheduled for pretrial this morning, which is why this consent order for conditional dismissal has two file numbers, because the attempt was to consolidate and make a global resolution. Accurate?
Yes.
Correct.
Okay. Okay, so I have here, Ms. Coleman, that you would like to enter an agreement with the plaintiff whereby you agree to have the case dismissed against you today upon the condition that you will vacate the premises on or before the end of the day on January 31st, 2024. Does that sound complete and accurate to you?
That is correct.
Okay. And I don't see any additional terms and conditions. So you have the right in this matter to proceed to a jury trial. Do you understand that right?
Yes, I do.
And you have the right to be represented by an attorney at these proceedings, and you are being represented by Ms. Pereira from the Office of Legal Services. So you want to waive your right to trial in order to move forward in this way of having the case dismissed and you move out?
Correct.
Anybody threatening you to get you to waive your trial?
No,
Has any promises been made to you and to get you to waive your trial?
no,
Okay, and you understand that partial performance will not satisfy this agreement. That means that you're supposed to vacate. That means you gotta take all your stuff too. You gotta turn over the key by that date and time too, in order to be compliant. You recognize that?
yes, I do.
And if you were going to have a walkthrough, which I'll let your attorney advise you, but I wouldn't move out of house without a walkthrough. You would need to schedule and have that done before the 31st of 2024, January. You understand that as well?
I understand.
Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the right to trial and you want to return to the court within those 3 business days and request to have this agreement set aside, okay?
Okay. Yes, Your Honor.
Do you have any questions?
No, I do not.
Any additional matters for the record, counsel?
No, thank you, Your Honor.
Thank you. You're all set, Ms. Coleman.
Thank you. Have a great
You're
day.
welcome. Same to you. Let's see.
Your Honor, I'm on the next one as well. I did file my appearance, but I do have a paper one in case it's not. That needs to yet.
Raheem Alekneal, that's you, sir? Okay, and so we do have an appearance filed by you, Ms. Pereira, on behalf of Keisha Gonzalez. This is Ms. Keisha Gonzalez. Okay, did you meet with Mr. McNeil and have you worked out a resolution, or how are we moving forward today?
Yes, Your Honor, we were able to talk earlier today, and we do have an agreement. I have a copy of it here. If we can just put the terms on.
Okay, let me officially call the case. This is file number 23-02094 LT, Raheem Alekneal versus Keisha Gonzalez, counsel appearance.
Veronica Pereira on behalf of Ms. Gonzalez, who is present to my right.
Okay, you can state the terms of the agreement on the record.
Thank you, Your Honor. The parties have agreed to do a consent order for conditional dismissal, and the parties agree that the total owed is $1,000 through the period of January 31st, 2023, and that defendant will pay the total owed on or before January 12th, 2023. The parties agree that if the defendant defaults on the agreement, we will use the 4B box so the case can proceed without further notice. And the parties also agree that partial payment will not satisfy the terms of the conditional dismissal.
Sir, is that an accurate understanding of how you want to move forward?
Yes, and that is like January 2024, not 2023.
Apologize, yes.
That's common.
Yeah, if
It'll be March before I start putting 2024. That's why I use this.
Yes, thank you.
The only question,
Counsel.
if she's paying by the 12, which she said by January 12th, 2024, okay, if not, then I need to she leave or.
Okay. Well, this is a conditional dismissal. So what your recourse is you're agreeing to dismiss the case today upon the condition that she does whatever you state that she's going to do there, which is pay that amount by the 31st?
The 12th.
The 12th of January 2024?
Yeah.
If she does not do that, then you can file a motion. The case will immediately enter against her in judgment in your favor.
Okay.
But you have to come to the court to file that, okay?
Yeah, for sure.
Okay, and then after that happens, then you can seek writ to execute the judgment against her, okay?
Okay.
Do you have any questions?
No.
Okay, she just gave you that paperwork. You want to look over and sign that?
Yeah. I think I love.
Oh, right here.
Thank you. Okay, so once again, here it's a consent order for conditional dismissal. And the terms are that you're agreeing to have the case dismissed today upon the condition that you'll pay past due rent of $1,000 and that you will pay the total owed no later than January 12, 2024. That's your agreement, ma'am?
Yes, ma'am.
You understand that you had the right to have a trial in this matter and you had the right to jury trial? You have the right to be represented by counsel. You are being represented by Ms. Pereira from Legal Services. You want to waive your right to trial?
Yes, ma'am.
Anybody threatening you to do that?
No,
Anybody make any promises against you to get you to waive your right?
no.
Okay, you understand that partial performance won't satisfy this?
Yes, I do.
Okay, so you gotta pay the full amount. You can't pay $999.99. You understand that?
Yes, ma'am.
That's what will happen if you don't pay the full amount.
Come down and try to put me out for 1 penny.
Yeah, he has the right to do that because you're agreeing.
Yes,
And you
ma'am.
can't pay on the 13th.
Yes,
You understand that?
yes,
You gotta pay it on or before the 12th, 2024, correct?
yes, ma'am.
Okay. You have 3 business days from today's date. If once you leave here, you realize, you know what, I misunderstood the rights trial. And I want my trial. You need to come back to the court within those 3 business days and file a motion to set aside judgment. We will set it for a hearing, okay? Do you have any questions?
No, ma'am.
Any additional matters for the record today? Any questions for you?
No.
Any additional matters, counsel?
No, thank you.
We'll get you a copy of the